We are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and today's host. Before we get in and bring our special guest on, I want to make you aware of two things. Go to Crypto Law and you will see a Connect to Congress tab. We've made it very easy. It is a message that goes to all of your congressmen and U.S. senators based on your address, basically calling for that subpoena to be issued. We are tired of the letter writing campaign by the Financial Services Committee. There's been a threat to issue a subpoena. We need to follow through. So that's not an empty threat. Take the 30 seconds that it takes. Get the messages out there. We want Gary Gensler to be subpoenaed and the documents that have been requested repeatedly, that request to be honored. And no longer do we want his voluntary participation. We want him forced to do it. And the second thing is that Crypto Law started an Instagram account. Let me make sure I get it right. On Instagram at Crypto Law USA. Let me remind everyone, there are no sponsors for Crypto Law. There's no money being made or anything like this. The people that help me do this because they want to provide good content for people in this very important area. And so please take the time to follow them. If you don't follow Crypto Law, follow Crypto Law. Things like that matter to these people who are helping. It matters to me, and I really appreciate it. Again, no sponsors. This is all just the facts and where we're headed in the law and all the things that we do. Let's bring on a very special guest to Crypto Law. I think it may be his first time ever. James Murphy. How you doing, James?
Fantastic, John. Thank you so much for having me on the show. I've never been on Crypto Law. It's my first time. It's a real honor to be with you, and I'm looking forward to having some fun.
Well, thanks. Listen, everybody follow James at MetaLaw. Everybody knows James. He's one of the sought out legal experts in this field. Very successful private attorney who's retired, ran a big law firm, all those things. He was sitting next to me in New York at the Coinbase hearing. And what I want to do right now is we're going to recap that hearing, talk about a couple other things like Caitlyn Long's lawsuit and custodial bank. But James, give us like the 1 minute sort of 30,000 feet overview of what happened at that hearing last week.
Well, this was the hearing on the motion to dismiss, an attempt to get rid of the case right here at the beginning. These motions are rarely successful. Normally, when I would be talking to a client, I would say, we're talking about single digits percentage chance of winning. I think this is an unusual case where the chances are much greater than that. But big picture, this judge was loaded for bear, really smart, really aware of the technology and the terminology that applies in the crypto world. She's really up to speed on DeFi because of her ruling in Uniswap. And so she dispensed with any argument by the lawyers, which I can tell you throws a lawyer off balance a little bit. And she said, look, I've got questions. And so she hit the defense with 2 hours of questions, and then the SEC with, I guess she started with the SEC and then the defense, and it was 5 hours of questioning, and she had 14 pages full of questions, really good questions, really smart judge. So I'm hopeful that she comes to the right decision.
Yeah, I've put it up at the 40% mark. I'm with you. Motion dismiss. I normally would say, listen, 5% is the highest you're going to get. But I like you, I've put this one up there. I didn't necessarily say it's 50-50, but a 40% chance for a motion dismiss. I don't know if you think I'm low, high, or what do you think about that?
Well, I went in, John, thinking 60% before the hearing.
Right.
And then I came out of there certainly below 50, unfortunately. But again, people need to understand the context. When you're talking about 30, 40% chance, that's very, very high. Yes. Remember, Ripple, they didn't win on a motion to dismiss. Garlinghouse and Larson, they lost and then ultimately won on summary judgment. The only way this judge gets embarrassed is by being reversed by the Second Circuit Court of Appeals. And the only way that can happen is if she grants the motion to dismisses the case. The SEC will then immediately appeal, and she could, run the risk of being reversed, where this where the court would say, we're not saying that you got this case wrong. We're saying you need to let it go forward to summary judgment. And so the safest course for a federal judge is to allow the case to proceed to discovery.
You know, that is an outstanding observation, James, that really no one that I've seen has been making. And I just want to follow up on that. You know, you're a successful attorney. You've been before these federal judges in that same courthouse on the Southern District of New York. So is it your position? Are you saying that if a judge really feels strong that maybe the SEC is in the wrong, the better path is to deny the motion so that you can maybe make a bulletproof summary judgment argument or something like that? Is that where you're headed?
Well, it's the less risky path for the judge to permit it to go to discovery and summary judgment. And remember, the standard on a motion to dismiss is really, really low. It's a low bar. All the SEC has to show is they've made out a claim that is plausible. And because there's so much confusion, unfortunately, about how these tokens may or may not be considered securities, arguing something that sounds plausible is not that hard. And so it's a very low bar. And I pointed out months and months and months ago that the one judge in that courthouse that I've appeared before who really doesn't care about being reversed is Judge Rakoff. And he's got that Terraform Labs case now. But the rest of the judges actually care. I mean, there's reputational issues because this is such a high profile case with so much at stake. It's a bad look to get reversed by the Second Circuit.
All right. Well, listen, I want to turn your attention to what I consider the biggest moment in the hearing. When it happened, I could have got thrown out because I almost had an involuntarily like, are you kidding me? Did you just say that moment? You and I simultaneously turned to each other with our jaws dropped. I saw Paul Graywell, the chief legal officer of Coinbase, who sat in front of us, immediately turn to his colleague, like, did the SEC really just say that? And it's if we could bring up the Bitcoin, you tweeted it out right here, James, where the SEC lawyer told the judge that Bitcoin's not a security, quote, because there is no ecosystem behind it, end quote. And it's funny because I leaned over to you and said, everything this guy is saying about these 16 tokens or 12 tokens or whatever equally applies to Bitcoin. And I was trying to figure out, how's he going to distinguish it? I was waiting for the judge to say, well, what about Bitcoin? And then he uttered that. What was your honest reaction when that was said?
I was shocked. Because it's demonstrably false. And it was interesting, just today, Lynn Alden put out an analysis of how is Bitcoin doing. And it's there on X if you want to look it up. And it's really well done, like everything that she does. And at the beginning, it talks about, coincidentally, the enormous ecosystem that Bitcoin is operating within and the hundreds of companies involved and the maintainers of the code and the stuff being built on top of it, the ordinals and other things that are happening with the Bitcoin blockchain. And she uses the term ecosystem. And, I don't know if she's paying attention to the hearing, but it's clearly demonstrably false. Unfortunately, the judge didn't say, what are you talking about? We need to remind ourselves that we're kind of experts in crypto and Bitcoin and the whole industry and how it works and how blockchains work. And judges are not, even though she's really, really smart. And so she didn't say, what are you talking about? But the bigger issue, John, is they made this up entirely. Here's a new formulation for you of what a security is. Here it is. Yeah. Asset plus ecosystem equals security. Now, go find that in any case. Go find that in Howey. Go find that anywhere. It's just like the Hinman thing. You know what? Look at whether it's sufficiently the SEC does not get to make up these tests. Courts decide what qualifies as an investment contract, and on the spot, the SEC is coming up with this brand new formulation that has no support in any case.
Yeah, I mean, ecosystem, network, these can be used interchangeably. If you listen to Michael Saylor, arguably Bitcoin's biggest bull, a person who has got billions of dollars invested into Bitcoin, talks about it being the most secure network ecosystem the mankind has ever seen. And so it's crazy. Stuart Alderati put up an interesting tweet. Let's bring Stuart's up if we can. Here, where he's basically saying, let's go to Howie and an ecosystem of oranges. In my opinion, and it's true, because you're investing in this ecosystem, which would be basically planting the trees, harvesting the oranges, selling the oranges to local grocers or local distributors. That is an ecosystem, an agricultural ecosystem. And it's what you said, that they're literally making things up as they sit in their office and they pontificate this crap. And they've revisited another thing that they made up in the XRP case that we're going to talk about. But also, I think Paul Graywell also had a tweet as well on this very issue, as you can see, here. And this one is the tokens themselves. Are they securities or are they not securities? And there was a concession that, well, the token itself isn't a security. And I just want to take a moment for everyone to realize that XRP holders are the ones who achieved that. Because when we got into my entire amicus brief on behalf of XRP holders had a section said the token itself is never the security. The underlying asset in an investment contract is never the security, just like the beavers and the chinchillas and the condos,
Right.
Weren't as well. And so it really is crazy. But let me ask you this. What's your most important takeaway from the case, from this hearing and what's going on right now?
Wow, I hate to be negative, John. It's not what people want to hear, but the judge said a couple of times, I'm just not understanding the distinction between the original issuance of the token and the trading on the secondary market, and why the answer should be different as to the first compared to the trading on the secondary market. That is what took me down from 60% to under 50%, because I think that she did not understand the Ripple decision. And this happened in Binance as well. And that really, really bothered me. In Binance, the judge said, so why is it that these sophisticated hedge funds and institutions should get the benefit of the securities laws, but unsophisticated people should not? Is there any basis for that distinction? This is completely wrong. This traces to the wrong take from Charlie Gasparino after the decision. She never ruled that. What
Right.
she ruled was, in the first instance, Ripple sat down at the table and negotiated with institutions to make an investment in Ripple, and you're going to get these tokens. And in exchange for that, you're going to agree to a holding period, and Ripple's going to agree to some stuff, and it's going to be in writing, and we're going to sign our names to it. You know what that's called, John? Of course, it's called a contract. And the institutions are making an investment in Ripple. It's an investment contract is the argument. Whereas there's none of that on the secondary market. It's clear as a bell, and I don't understand, and I hate doing this. I truly, truly hate being this Monday morning quarterback lawyer guy, but I don't understand why the lawyers didn't make it crystal clear. Your Honor, I'm sorry, you've got this wrong on Ripple. It's none of what you said. There is no contract on the secondary market, and that's why it's not a security.
Yeah, and here, talk about two things. One is that something that drives me insane is when Judge Torres's decision came out, there were people, commentators and lawyers saying, wait a minute, this violates the spirit of securities laws because, sophisticated investors versus non-sophisticated. Show me any language in Howey that distinguishes sophisticated investors from other types of investors. It doesn't exist. But there's another thing that raised its head, and it's the embodiment theory. If you remember, there's a moment where the SEC lawyer, and I had literally deja vu in my head, almost spin around, because he said the token itself is not a security. It embodies all of the inducements and promises that were made by the issuer. And I want to remind everyone, the very first time this made up theory by SEC lawyers appeared was on page 24 of their opposition to our motion to intervene. And as you see there highlighted, it says the XRP traded even in the secondary market is the embodiment of those facts, circumstances, promises, and expectations, and today represents that investment contract. So you can see there is no citation. And I'm sure as a lawyer who has done many briefs, James, when you read that, you would expect there to be case law, right?
Right.
Right.
Yes. Whenever you're stating a fact, you cite to the record. When you're stating a principle of law, you have to cite to a case or a statute, and they've got nothing.
Right. And so they came up with, I call it the embodiment theory, or actually Lewis Cohen did that. I called it the representation theory, where they said the token's not a security, but it embodies the promises and the token represents a security. And it's like, what? You talk about in the amicus brief I wrote, I literally said this amounts to legal gibberish. It's just made up kind of words, and it's a word salad, and it tries to sound like it's impressive, but it's nonsense as far as legal precedent.
But it can fool people, John,
yes.
Because that's exactly what they're describing is exactly how stocks work. When the company initially issues a stock, that's a securities offering, and thereafter it remains a stock, as what is being traded is an interest in the underlying company. You own a little tiny piece of the company, and the stock represents that. So they're saying something that if you're unsophisticated would make sense. Oh, yeah, I get it. Just like a stock. But no, the courts have been clear. You got to have a contract or some kind of commitment that you are investing in the underlying enterprise and receiving in return a right to profits, assets, income, or something from that enterprise. And these tokens do not represent that. They are just code, trading. And here's another thing that, again, I hate being the money morning quarterback. I've said this too many times, but they didn't help the judge understand the distinction between investing in an underlying enterprise and aligning your personal interests with the underlying enterprise. These are two different things, and they're very different. So Mark Cuban just sold a significant chunk of the Dallas Mavericks. That's a security. He sold equity in the Dallas Mavericks. That's a security for sure. But if I bet on the Dallas Mavericks, I align my interests with the Dallas Mavericks. I have no input into who's going to win that game. It's all on them. And my interests are totally aligned with the Mavericks. And they have an ecosystem. It ain't a security. I just made a bet on how they're going to do.
Yeah, listen, what they've done is two things. Well, at least one thing is they've conflated common enterprise with common interest. And those are two very different things. You can't substitute, the XRP holders have a common interest in Ripple because Ripple owns XRP and so do they. And they both would like to see it go up. That is not the law. All right. And you can't just substitute common interest. You brought up ecosystem again. And just before we went on, I saw that David Schwartz CTO of Ripple, and you had an exchange on X where he was like, how are the miners, right, not part of this ecosystem that Bitcoin doesn't have? And aren't they, I had always said when I first filed the case against the SEC, and I got up and I said, listen, this case and the allegations that the SEC are making, it threatens all of crypto. And I said, you could make the same arguments against Bitcoin. You could call the mining a common enterprise. And you could, all the things that the SEC is doing. Now, granted, they've moved on from Bitcoin and have conceded that it's not. But I want to remind people of why what we're doing is so important. In 2013, people at the SEC, some of them did argue that Bitcoin was a security. And they argued that all the factors of how we applied. People pay money for Bitcoin. They have an expectation of profit, and they're relying on the efforts of the miners, and the whole mining is the common enterprise. They were making that argument in 2013. I don't agree with it. I'm just saying that they were making that argument. And so, it's very unfortunate that we have an inept Congress that's just sitting on its hands, because we're going to see these cases. The judge in the Coinbase hearing brought off Judge Rakoff, which you've mentioned, in the Terraform Labs case, and she clearly brought up the Ripple case. Any insight that you have, whether she thinks those are inconsistent rulings or they're very different because you can distinguish them, or she favors one or the other? Anything you can share from your perspective?
Well, John, this is a little nuanced. I think lawyers could talk about that for a couple of hours.
Yeah.
In both cases, we're talking about the issuer of the token. Now, by the way, it's kind of debatable whether Ripple really is the issuer of XRP, but leaving that aside, as opposed to Coinbase, where it's just a secondary market. And in the Judge Rakoff case, I'm not saying he was way, way off base, because Do Kwon was saying, if you buy this token, it's like owning equity in our thing. And if you buy this other thing, you can get an income stream from it. And when he is dealing directly with the investors in the first instance, there's case law to support the idea that that's an investment contract. So it's not a radical notion. And Judge Rakoff sort of subtly steered into the secondary market stuff, but he didn't quite say as much as people think he said. He said this, Luna trades on the secondary market. He did not follow it up with the next sentence saying, and all of those trades are also investment contracts. He didn't say that. He did refer to these tokens as securities and like headings of his decision. And then the stable coin thing, I simply disagree that a stable coin meets the definition of Howey. Right. And then with respect to Ripple, there is unfortunately a misunderstanding of the distinction that Judge Torres made between the initial offering and subsequent offerings. It had nothing at all to do with the sophistication of the buyer. It had to do with, are you entering into a contract with Ripple? Answer, with respect to, in the first instance, yes. With respect to everything else, no. And when she said, when Ripple sells on the secondary market and when Garlinghouse and Larson sell on the secondary market, it is not a securities transaction, then the SEC says, hey, Judge, don't worry. She says nothing about the secondary market. She made no ruling about the secondary market. To me, it couldn't be clearer. If Garlinghouse, Larson, and Ripple can sell on the secondary market XRP and it is not a security, then anybody else on the face of the earth can trade on an exchange XRP, and it cannot be a security.
Yeah, I agree. And I think that unless Judge Failure has a fundamental disagreement with Judge Torres, which I don't think she has, then I can see that imparting her. Part of me was hoping that Judge Failure would look, these are blind bid ask transactions. If it is a blind bid ask and absent a Do Kwon mass marketing campaign, which is saying to the world, buy this and it's like equity. But if it's just an intermediary like Coinbase and a blind bid ask, no one knows who's selling, no one knows who's buying, that it's impossible for that third factor to be met, right? A reasonable expectation on the efforts of others. You don't know who you're buying it from. How do you invest in the efforts of the promoter if you don't know who's selling? There's a part of me, and maybe that's wishful thinking, that she would latch on to that and there would be a successful motion to dismiss. Do you agree that she's probably not going to rule on major questions?
Yes, I think she was pretty clear about that, as was Judge Berman Jackson and Binance. And there's a reason for this, and that is they are the trial level judge. To make a decision of this magnitude in a separation of powers, clash of titans, takes a lot of chutzpah as a judge. And so you see people on X interpreting what I and others have said about she doesn't want to touch the major questions doctrine as this case is not suitable for major questions doctrine. I disagree. I bet you there are 5 or 6 votes at the Supreme Court to toss this entire regulation by enforcement effort of the SEC on the crypto industry, toss it on major questions doctrine. I am not surprised an individual federal judge does not want to take that step. And by the way, that's kind of how it's happened in the past, is that you don't, until you get to the intermediate appellate court or the Supreme Court, you don't actually win on major questions doctrine. But there are six votes, in my view, that would toss the case on major questions doctrine.
I agree. Listen, as far as meeting the economic importance kind of standard, if you just take the foreign exchange market and how crypto, that's trillions of dollars a day. The cross-border payments alone are, I think, is $500 million a day. So I do think that blockchain technology and cryptocurrency would meet sort of that test of that it's of economic significance. And clearly when the chairman of the SEC, incoming chairman of the SEC, testifies under oath 2 years ago that Coinbase, is out of the purview of the SEC. Coinbase is outside of the SEC and CFTC's jurisdiction. And then 2 years later says, no, everything on Coinbase is a security except for Bitcoin. I think that's ripe. And I think that you might be underestimating the votes. It might be more than 6.
We'll see. I mean, one of the lawyers made a really good point, John, and that is, Your Honor, it's not just math in terms of economic impact. Look how much time and effort is going on in Congress now. It's like 12 or 20 bills, whatever, and hearings and all of this about our legislative system trying to grapple with a tough question of how are we going to regulate this going forward. Now, why we struggle more than the European Union is it's got 27 different countries to bring together to come up with their comprehensive MiCA regulation is just another instance, an example of the dysfunction that we're confronted with here. But you can't suggest that the Congress would spend this much time and effort on this, and it's really not that important.
Let's say we all know that Ripple case, XRP, was the first token to get judicial clarity. What would if Judge Failure was just playing better poker than you or I believe, and that 60% that you thought that Coinbase could win, I thought 40%. If that turns out to be true, what would that mean for crypto, James? If Coinbase wins either a partial motion for dismiss or the full thing, what's that mean?
Well, it would be huge. It would mean that trading of crypto on secondary markets in the United States is legal. A dark cloud would be removed. Now we have to give the caveat that there are appeals, and this is one judge's opinion, but this is the big one. Coinbase is the dominant player in this space. And so the 10 or 13 tokens they picked out are representative of the whole. It's not just these 13 are good now. It pretty much is they're virtually all good to go that are listed on Coinbase. That's what it would mean. It would be very, very big. Hopefully, it would kick a leg out from under the Operation Choke Point 2.0 stool, where people are having their bank accounts closed because they have some involvement in crypto, when it's kind of declared legal. And so that basically the whole community gets the certainty that XRP got thanks to their great lawyers at Ripple and you. It lifts a dark cloud over it. And then, anything's possible in terms of new ETFs, and the adoption generally within the United States could catch up to all these other countries that have adoption because they have a comprehensive regulatory framework.
Yeah, certainly. I know that we'd be remiss if we didn't bring up the right that the SEC would have to appeal, but I don't think a favorable ruling for Coinbase could be overstated. I think that even though the SEC could appeal it to the Second Circuit, when you have tens of thousands of token holders coming in as amicus, and you have all these associations and legal scholars and everyone filing amicus briefs on an appeal, for the Second Circuit and certainly the Supreme Court say, nah, we think the judge got it wrong, I don't see it happening in the least. And so I'm with you. I think a Coinbase victory is checkmate in a lot of ways. And so we'll see. Listen, you brought up Choke Point 2.0. We would be remiss to end, and we only got a couple more minutes, but I do want to highlight one of the warriors out there, someone that I had the pleasure of meeting thanks to you. You had set up a dinner a couple years ago, and we got to break bread with Caitlyn Long and her fight against the Federal Reserve. So I just want to spend a couple minutes, James. Do you believe that case is a significant case?
It's hugely significant, John, and I know you know that as well. Thanks for the softball. It basically is everything with respect to on and off ramps into crypto. You have got to have access to the banking system to send wires, to send money to an institution that can send it to Coinbase to buy, or wherever to buy into crypto. On and off ramps are absolutely critical. And so the government has been very smart in trying to choke off these on and off ramps and opposing Caitlyn at every step. And you just got to say, what a warrior. She's one of the smartest people I've ever met in any industry. She's arguably the smartest person in crypto. I mean, she went to Harvard Law School. And I don't know if we lost my video there, but in any event, she went to Harvard Law School and did 20 years at Wall Street. You and I have met with her. She can talk Austrian economics all day. She's just an absolute genius. And the Fed says she's not really good enough to serve as the president of a bank, which is so ludicrous when you think about the incompetence at a place like Silicon Valley Bank, where they couldn't even figure out that their portfolio securities would collapse when interest rates went up like everybody knew they would. She is a genius, and this effort to stop Custodia is really, really outrageous, and I think she's got the better argument in court, and we all should be rooting for her.
Yeah, James, as far as Caitlyn goes, let me make it clear, though, we were in law school around the same time in the Boston area, just so the record is clear. Now, of course, she went to Harvard, and I couldn't get in, nor could I afford it. But let's be honest, I couldn't have gotten in, even if I could have afforded it. So she's great. And what everybody needs to know about that case is she has this revolutionary idea where we're going to do away with fractional banking. And you have actually a bank that will have more than 100% in reserves. You got 10 Bitcoin, you can have your 10 Bitcoin at any time. You got $100,000 in the bank, you can come get it at any moment. There could never be a bank run because they have everyone's assets 24/7, 100% of the time. And so she is a warrior. She is brilliant. Listen, we're out of time. I know we lost your your visual, James, but I have a feeling that Crypto Law is going to have you on in the future. Thanks for being there. Everybody have a safe week. See you next Tuesday.